Okay, this is control number 8, claims and notifications and records. And in this first part, part A, I'm going to just be covering some basics about the type of construction contracts and risk, and just explaining why that matters, that you understand it so that you can manage it properly. And I'm going to try and avoid this being too theoretical, but you know, we generally have types of construction contracts that form a specific basis. It could be lump sum, which essentially means it's not remeasurable. You're taking the risk on quantities. It can be remeasurable, which is the one probably most familiar to most people, where quantities can be remeasured, so the risk on measurement sits with the employer. Design and build, where you take full responsibility for the design. Turnkey, and the difference of turnkey is literally you have a facility constructed to the point where you can literally give the client the key and he can walk in and operate it. EPC is where there is a performance element, so it's turnkey plus you're guaranteeing an output performance. So you're saying the factory will produce a certain amount of whatever it is you have contracted to deliver, and you carry full process responsibility. The other one then is maintenance type contracts, and all of these can either be fixed price contracts, and that is you take as the contractor the risk on price inflation, or they can be remeasurable for repayment for inflation. Okay, so types of construction contracts that you will typically see in South Africa: obviously the JBCC for the building, NEC, FIDIC in all of its various forms, the Red Book, again, which most of you are familiar with. You've got the conditions of contract for electrical and mechanical works, the Yellow Book, the conditions of contract for design and build and operate, the Gold Book, and conditions of contract for EPC and turnkey projects, the Silver Book. Then you've got NEC, construction and engineering contracts. Obviously bespoke conditions of contract. Some major employers have their own conditions. And then the final two, GOTO and GCC. So it's important that you at least understand what the various forms of contract are. And generally these contracts, and I'll get specifically into different clauses for notifications in later modules, but they're typically addressing matters such as the responsibilities of the contractor and those of the owner, and I'll cover that in more detail in a minute. The administration of the contract by the owner or his professional team, terms relating to separate contractors and to the contractor subcontractors, procedures for initiating change in the work of the contractor. And I think that's one of the most fundamental reasons why construction contracts are so complex. It's to administer change in a way that can be managed, and the risks are understood. Provisions for addressing delays in time performance, procedures for payments, requirements for indemnity, insurance and bonds, procedure for contract suspension and termination, procedure for project closeout, and miscellaneous terms such as assignment and government law, and especially on bespoke contracts, which I'll talk about in a minute. So what are the major things you need to check? If you're at tender stage or post-construction, you've been awarded, you really need to look at the condition of contract, understand it. Is it a standard form or has it been amended? And if it's been amended, you really want to look out for the notification requirements. For example, are there time periods for notification that are in the standard form? You must understand them. Or if they've been amended, what is the consequence? Is time barring in the contract? So do you have to give notification within a specific time period, which is very common, and failure to do that means you lose your entitlement for a claim later on. Is there an approval process that you have to go through in order to put a notification in? So for example, you might have a shop drawing approval process or a material submittal approval process to go through before you can say that this element is in delay. And you really need to understand risk transfer, and I'll cover that in a lot more information, but typical things like unforeseen ground conditions, weather, unforeseen physical obstructions, etc. You really need to understand what risk have you taken on. So one of the things that's really important to not become is what I call contract complacent. Often we are so used to going on contract after contract with the same standard form that we can become complacent. Even if it's a standard form, it's really good to get the team together at the start of the project. If you're the commercial manager, if you're the QS, or if you're the engineer, operational executive, and run through and remind everyone of what the contractual process is for notifications. If you've got new projects, different circumstances, and that's obviously the one major challenging thing about the construction industry, is that every single project is different. So what might have been an insignificant risk on one contract is a significant risk on another. You know, ground conditions, for example, if you're digging a deep basement on one contract and you hadn't got that on your last, you've got to be really aware of the provision of unforeseen physical obstructions and have to manage that extremely well, whereas it mightn't have been an issue on previous projects. So it's really important to sit down and look at the contract again at the start of the contract or the works and define what risks do you really have to manage, particularly if you're looking at amended conditions of contract. It's really important, you know, and I really feel strongly that custom drafted and industry draft forms do not mix, and you see it so often in our industry where, you know, clients will get legal eagles to amend standard forms without really fully understanding the consequence of what is the impact of that amendment. But you need to know and understand your risk, what the notification requirements are, any special obligations that an amended form has placed on you, and any additional clauses. And you've got to disseminate that to your team. You cannot assume that people understand or know those. So this is just a contractor self-qualification. You know, if at tender stage, if at project assessment or at project kickoff, you've got to ask yourself these questions. Do you have the right experience to perform this type of work? And that's so often the case. You know, we file into a project without really understanding, do we have the right people? And the consequences are truly horrific, you know, in terms of delay, in terms of rework, in terms of poor quality. So you really got to ask yourself, do we have the right people to execute this? You know, has your experience with this type of work been profitable? And if not, why not? And how can you manage that moving forward? Do we have enough experience with projects of this size and complexity? And what do you do if the answer is no? Do you recruit someone in? Do you joint venture? Do you partner? Do you hire in some consultants? But you can't just ignore it. And so often again in construction, we think construction is construction. How difficult can it be? But again, the consequence of getting this wrong can be truly horrific. Do you have enough experience with this type of project delivery method? You know, if it's a design and build project, have you adequately thought about the process around that? Do you have the available site supervision with successful experience running projects of that type, size and complexity? And again, often you see, you know, someone who's been really successful in a particular line and then he's taken and put on a completely different type of project without, you know, the proper support and supervision and mentoring. And, you know, you're really setting people up for failing if you don't analyse what are you asking or requirement to do. Again, at tender stage, you've got to ask yourself, can you get a bond for this project? Will a bond for this job eliminate or significantly reduce your capacity to bond other foreseeable or more desirable work? It's an important consideration. And one of the things at project selection I really encourage people to do is to try and analyse, will we make money on this contract? Is the risk transfer you know, something we can manage in a way that we could actually make money here? Do you have the home office support? And what would the potential profit offset be if you encounter risks? So, you know, risk in construction contracts, owners, contractors and design professionals, architects and engineers are required to deal with common reoccurring project risks, which affect all of them on almost every single project. And again, depending on the type of project, depending on the environment, the site conditions, the time of year, you know, you have risks that are common to all projects, but some risks may be unique or particularly problematic. So it's something you've really got to understand. And again, just not to get too theoretical about this, risk is the probability of an event occurring and a consequence of its occurrence. So you've got to sit down with your team, again, if you're the commercial or operational lead on this project, and sit down and say, okay, what are the major things that might materialize and how do we manage those? Because these require consideration in the context of that specific project. Coming back to the unforeseen physical conditions I mentioned, you know, if you're doing a highway extension through a town, you're going to encounter a myriad of services and underground obstructions, completely different to a risk you're going to manage in a greenfield site. So you've got to sit down as the operation or commercial lead on that project and really understand the process and define the notification requirements and the record keeping in order to manage and protect your risk for that item. The fundamental point is that risks cannot be ignored and should be managed as efficiently as possible. So what are the key risks covered in construction contract? You know, weather, unforeseen physical obstructions, like I've mentioned, time for completion, availability of labour and materials, bankruptcy, late payment, non-performance of contractor or nominated or selected subcontractor, design defects, planning and building permissions, breach of building regulations, defective materials and work. I mean, the list is endless, and I'm going to get more specific about what are contractors' risks and what are employers, and explain what that means in a second. You've also, if you go into the area of design and build or EPC, have significant additional risks. And this is something, again, that's often not fully understood at tender stage or by project teams, because if you've been used to doing lump sum or remeasurable type contracts and you go into a design and build environment and you don't adequately understand or manage these elements, then you can really, really see catastrophic consequences. So I'm talking about things like design. You know, in a design and builder EPC, you are responsible for the design, the performance of it, the functionality of it, and the delivery of it. Quantities, always on a design and builder EPC, you're taking the risk on quantities. And because the design is your responsibility, it can be quite difficult to define the contract quantities at the tender phase. So you've really got to manage that well. Environmental concerns, again, is your problem. Permitting, getting your building permits, getting your environmental permits is often the responsibility of the contract. Financial requirements, you know, if it's a PPP or you're the design and build contractor reporting to a PPP, you can be held liable through collateral agreements to the funding institutions. And again, the consequence of delay, you're not only liable to the employer but also potentially to a financial institution, because they'll have suffered a loss through your non-performance. Cost and quantity estimates, design errors and omissions, construction defects and deficiencies, which is common on all contracts. Site location, you know, you might be responsible for the identification of the right site location. Access issues, geotechnical concerns, delay in performance, and the building not fit for purpose. So what does that mean? You know, if it's a design and build, or in particular if it's an EPC where you're responsible for the output performance of that building, your obligation is always fit for purpose. In a normal construction contract, you know, you need to use reasonable skill and care. That's the legal definition for the standard of care that you need to apply. But fit for purpose is an absolute obligation. It either works or it doesn't. If it doesn't work, if it doesn't perform to the requirements, you're responsible for the contractor for getting it right. So if you are doing the design and build or EPC of a water treatment plant and the water purity coming out is not to the required standard, it's your problem to fix it or compensate the employer appropriately. So the above question and view of risk assessment and allocation can be broken down into three questions. Who can manage the risk most cheaply, efficiently and easily? Who benefits the most from its management? Who has the greatest incentive to manage it? So let me give you an example. Price inflation. It may be better to give that risk to the contractor, but he's going to price in a serious premium because it's an unknown risk. You know, but as an employer, you might want to have absolute certainty of cost from a financing point of view. So these are decisions that are really delicately balanced between whether they get transferred to the contractor or the employer. But the bottom line is, if they've been transferred, you know, to you as a contractor, you need to understand and you need to manage those. Because ultimately, the transfer of risk, whether you're a contractor accepting it, whether you're a consultant delegating it out to the different parties, or if you're a main contractor delegating this risk down to subcontractors and suppliers, the allocation decisions of that risk will have a dramatic effect on the cost of the project. So, you know, you're going to pay for that risk. If you're looking at a subcontract arrangement and you're going to make it fixed price, lump sum, you know, the subcontractor is going to price that in. Whereas if it's remeasurable and you've got a good contract administration and site team, he's only going to get paid for what he's done. So it might seem really attractive and enticing to always transfer risk, but you're going to pay a serious premium for it and ultimately can affect the profitability. So who owns the risk? And this is really important. This is one of the fundamental parts of this training. It's either going to be the employer, it's going to be the contractor, or it's going to be shared. And why is this important? Well, if the risk is the employer, simply you're entitled to be paid your cost if that risk materializes. And that's really important, especially from a notification requirement. You know, if you're in a situation where you've got concurrent events happening, so you've got inclement weather, but you've also got late information and other events happening, you really need to be conscious about how you record those, what you record, because you might find that the employer will turn around and say, well, I'll give you an extension of time due to inclement weather, and then you're fighting over cost. And I'll explain more in a second. The risk might be the contractors, and if it's your risk as a contractor, you're not entitled to an extra cost, and you also may be open to damages to the employer, liquidated damages, if that risk occurs and you don't manage it adequately. Shared risk. Those are risks where they're outside the control of the employer and the contractor, and that risk is shared. And it's extremely important to understand where this risk sits from a notification perspective. So which risks are the employers? Again, it depends on the conditions of contract. So the proviso over all of this training is read, and check the conditions of contract. But in most remeasurable contracts, which is currently the most common form that we deal with in South Africa, but it's changing towards a more lump sum, turnkey and design and build model. So you really got to read the contract. But typical employers' risks are delayed site transfer, so you can't get possession of site, and that causes disruption to your organization because you've been gearing up. Another one is unforeseen site obstructions or ground conditions. Something you've got to really be vigilant about as a contractor. So you've got to carry out your surveys, you've got to request all of the information, and if you've done what a reasonable contractor could have done, but you've still encountered unforeseen physical obstructions, you're entitled to cost and an extension of time if you have to deal with that event. Late information, the employer through vicarious liability and through his consultants is responsible if those consultants provide you information that's late and delays you. Inaccurate information, if you have to do rework, if you're delayed as a result of it, again, they are responsible for that. Consequence of variance are variations to the works. So, there's a common term that no variation shall vitiate this contract. The employer is entitled, or his design team, to vary the works of the engineer, but you can be reimbursed for any loss, disruption or cost that you incur as a result of that. You've got also late nomination of selected or nominated subcontractors and suppliers. Justified termination of a selected or nominated subcontractor. So if you've accepted a nominated subcontractor who is not performing and you validly determine under some standard forms the employer is obliged to renominate and you're entitled to an extension of time, but only on valid termination or justified termination. You've also got late payment. Obviously, as an employer, one of your fundamental duties is to pay the contractor, and then insurance is after taking possession of the work. If the employer takes possession of a site, however temporary or trivial, generally he becomes responsible for that. So, as employers, risks, if they occur, you are entitled to be paid your cost if that risk materializes. So what risks do you as the contractor then typically carry? Well, late delivery, cost escalation if it's a fixed price contract, poor workmanship is a massive one, non-performance of subcontractors and suppliers. You are responsible also for selected for their performance and managing them. Labour disputes, especially if it's site specific, insurances and risk on quantities if it's a lump sum contract. So if any of these risks materialise, you as the contractor have to bear the cost and will be liable for delay damages if the project is delayed. What risks are typically shared? Well, force majeure items, which are things completely outside the control of the employer, non-availability of materials or labour if it's fundamentally and can be proven that it could not be obtained, weather, and this is probably the most common one that you see on contracts. If there's a delay, the design teams are very, very keen to give an extension of time for weather, because you will not be able to recover your prolongation costs, your P&G or your disruption due to weather, because the employer can give you an extension of time, but you won't be able to recover your costs. And the final one is civil commotion strikes, and you've got to be very careful here. If it's a site-specific strike over something like pay or terms and conditions, that generally will not entitle you to an extension of time because it's something that you can manage. It's a commercial thing that you have to manage. Whereas if it's an industry-wide strike, or if you're on a site with multiple parties and there's a site-wide, like we currently, as this is being recorded, are on Eskom site at Casilium and Dupi, and if there's a site-wide strike rather than your own specific labour, then you can get an extension of time but no costs. So it's really important that you understand where these sit. So, you're looking at things like late delivery, cost escalation, poor workmanship, non-performance of subcontractors, labour disputes, insurance and quantities as critical things that you need to manage. So what's really important is that you sit down with the project team at the start of the contract, you re-communicate any standard terms, you look at the context of the project and say, okay, what risks are really major on this, and what do we have to do from a notification requirement, a documentation requirement, records, in order to manage that risk. And you also need to look at your project documentation system. Have you identified and reviewed every document that will be part of your contract? So often we look at the conditions of contract, but we don't look at the preambles, the bill of quantities, the specification, any schedules. And you have to also understand or establish at the outset the priority of those documents, so which documents take precedence over another. You also need to ask, has the standard contract or the contract been reviewed to determine if modifications to your standard project documentation system are required. So if you've got a doc control system that has, for example, standard terms of notification on it. They may need to be amended. If you've got a document control process where you're used to having 28 days notification requirements, but it's been shortened to 14, you need to understand and adjust appropriately your project documentation system. Does the contract have specific cost accounting requirements? Do you need to have particular cost coding, for example? Does the contract contain special notice requirements? So important. You know, as I mentioned at the outset of this, have the notification requirement periods been shortened, amended, or are you time barred if you don't notify within a certain period? Have you identified special notice and claim requirements? Are there special procedures or cost limitations on change order work? Does the contract contain unusual risk shifting clauses that the project documentation system should take into account? Give you an example of that. Unforeseen physical obstructions. The document might say it is the responsibility of the contractor. Well, under a normal contractor, then you need to do all that you can using reasonable skill and care to identify unforeseen physical obstructions. So if you've carried out surveys, if you've engaged with all of the utility providers and you've done everything a reasonable contractor could have done, and that's been documented, and this is a really important part, then you later on find something that no reasonable contractor could have anticipated, you can still be entitled to an extension of time with cost, despite the fact that the contract has been written to say that the contractor carries all risk. Do you also then need legal advice? If you've got special terms and conditions, do you need to get expert advice on how you manage those? So that's it under, you know, standard construction contracts and risk, and then we're now going to get specific into notifications around things like variations, instructions, and delay.